Good evening, everyone, and welcome to the Rent Stabilization Commission meeting of the City of West Hollywood tonight on Thursday, January 28th, 2021, and I call this meeting to order. Please, everyone, follow me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Mr. Secretary, may we have a roll call, please?
Commissioner Bergstein,
Present.
Commissioner Charity,
Here.
Commissioner Copeland,
Present.
Commissioner Kirby's,
Here.
Commissioner Maggio,
Here.
Vice Chair O'Keefe,
Here.
Chair Topshin.
Here. We have a quorum, everybody's present. All right, thank you. Next item is approval of our agenda. Has anyone had a chance to review the items before us tonight? Do we have a motion?
Move to accept as submitted.
Who was that? Commissioner Bergstein?
Sure.
We have a motion to approve the agenda. Do we have a second?
Second.
Commissioner Maggio, we have a second. Mr. Secretary, may we have a roll call?
Commissioner Bergstein,
Aye.
Commissioner Charity, Commissioner Copeland,
Aye.
Commissioner Kirby's,
Aye.
Commissioner Maggio,
Here. Aye. Excuse me.
Vice Chair O'Keefe,
Aye.
Chair Topshin.
Aye. The agenda is approved. Thank you, commissioners. Next is approval of the minutes from our last meeting on January 14th, 2020 via teleconference. Do we have a motion to approve the minutes as presented?
Motion to approve the minutes as presented?
Second.
Okay, we have a motion and a second. Mr. Secretary, may I have a roll call, please?
Commissioner Bergstein,
Aye.
Commissioner Charity, Commissioner Copeland,
Aye.
Commissioner Kirby's,
Aye.
Commissioner Maggio,
Aye.
Vice Chair O'Keefe,
Aye.
Chair Topshin.
Aye. And minutes are approved. Thank you very much. And the next, moving on to the public comments. Mr. Secretary, do we have public speakers tonight?
We do. We have Council Member John Erickson with us tonight.
All right. It's great. Councilmember John Erickson. Councilmember
Hello,
Erickson.
everyone.
Yeah, hi.
Hi, everyone. It's great to see you here from my living room. It's always great to be here with you all. In like true traditional wear, I'm wearing, of course, my Protect Safe and Legal Abortion shirt because we got Title 10 back with the gag rule today from the federal administration as we're seeing lots of changes, but wanted to come. I'm popping into every commission and board to not only say hello, although many of you already know me, but also thank you for all of the hard work that you are doing right now. We oftentimes don't say thanks enough, especially during this, what's the right word for it, crazy time that we find ourselves in. And especially as you all, as the Rent Stabilization Commission, have quite the behemoth in front of you with the work that you do, with not only protecting the most vulnerable in our community. If you are following the laws today, you know SB 89 and SB 91 are not perfect bills. It is impossible to find a perfect bill from Sacramento these days, but they are helping in the ways in which we protect those that are most vulnerable. But that is where your role will be so critical to those in our city that will be coming before you as we continue to see this pandemic ravaging those most in need. And I wanted to say thank you for that service now. I want to thank you for that service in the future, because this is where our renters need you the most, and making sure that not only West Hollywood's rent stabilization ordinance, which is the best, is not only continued to be maintained, strengthened through work that we have to do and must do, but also enforced through the ways in which you all protect those in our community. And that's why the City Council is working so hard to make sure we're providing that direct relief to renters themselves and all that we can do to continue to provide COVID relief to those that are most in need. And so I just wanted to come say hello and say thank you. We oftentimes don't get to thank you all enough. I know you have a busy agenda, but that's all I have to say. Thank you so much, Chair.
Thank you, Councilmember Erickson. Thank you for being here and for the words of support and encouragement. And it's really important these days to hear that. And hopefully we'll see you again soon.
I'm sure you will.
Thank you.
Bye-bye.
Bye-bye. Other public speakers, Mr. Secretary?
Not at this time.
Okay, all right, great. Then moving on to the manager's report. And we have Acting Rent Stabilization and Housing Manager, Mr. Jonathan Holub. This is your time.
Thank you, Chair. Vice Chair, good evening. Good evening, Commissioners. Jonathan Holub, Acting Manager, Rent Stabilization and Housing. Just actually following up for a moment on what Councilmember Erickson was talking about, SB 91, a very important piece of legislation that is about to, I told, come down the pike and be signed by the governor, hopefully within the next couple of days. It is an extension of the COVID-19 Tenant Relief Act. And like I said, I fully anticipate that it will be signed into law before the end of the current eviction moratorium, which ends on January 31st. This will extend all current eviction moratorium protections through June 30th, 2021. The division is closely monitoring this, and once enacted, we will update all the information on our website. To access that information, go to WehoTV.org, click on the coronavirus graphic at the top of the page, then follow the link to Renters Resources. Questions can also be addressed by emailing rsh@weho.org or by calling 323-848-6450. A link regarding rental assistance relief can also be found at the top of that Renters Resources page. In addition, further resources may be available through the county as the federal government, we hope, begins authorizing funds for tenant assistance. To sign up for notifications, tenants can visit the county site. I'll read it. I know that reading websites is somewhat fruitless, so I would just point out that it's also already on our social services webpage. Got that up there today. So, but it is www.211la.org/LA County/rent relief. Currently, it's not to sign up for the program because the funds are not available yet. But if a tenant is interested in being part of that program, they should sign up for email alerts. Addressing the look ahead calendar, next meeting, we've got 2 appeals, a compliance termination related appeal and a hearing appeal. Currently don't have anything on the look ahead for February 25th or March 11th. That could very well change because I do have a discussion, possibly some thoughts about changes to the regulations when it comes to valuation guidelines, at the very least a discussion about that. But I may move that up since it doesn't look like we're going to be having appeals come through on the 25th or maybe the 11th. I don't know yet, but we'll see what comes in. So that's the basics of my report. But I also wanted to talk about subletting because that was an issue that I know was of interest to the commission before I came in. And I wanted to just give a brief outline. Of course, this is an issue we can discuss further, but I know I may bring an item, in fact, depending on commission comments or what I hear from staff about how this issue has affected tenants. I'm not 100% certain whether it requires an ordinance amendment or a regulation amendment. Well, more likely an ordinance amendment, but like I said, it's certainly something we can discuss. What residents should understand is that whenever a natural person or an entity, whether it be the owner of a property or someone who rents from an owner, leases a unit or a portion of that unit to another person, then they fit the definition of landlord under the RSO. Also, anyone who's entitled to the use and occupancy of the unit is a tenant. Therefore, in the example of a tenant bringing in a roommate that pays rent directly to that tenant, the master tenant, that master tenant would be a landlord. And that creates a landlord-tenant relationship between the master tenant and the roommate. And just like any other landlord under the RSO, the roommate, just like any other tenant under the RSO, they enjoy all the rights of any tenant. And the master tenant is obligated to follow all the rules and regulations that the RSO creates. With respect to the subtenancy itself, this isn't to say that a property owner cannot possibly evict for an illegal not illegal, but for a subtenancy that violates the lease, or roommate that isn't authorized to be there in certain situations, but that's a different issue. What the master tenant cannot do, just like a landlord cannot do, is engage in self-help evictions, tenant harassment, reducing or eliminating housing services to the roommate, or charging roommates more than the lawful maximum allowable rent. In sum, the admonition for anyone considering becoming a master tenant means that they need to understand that this entails responsibilities, specifically the responsibilities of being a landlord. So information coordinators are available to discuss these issues more with people who are possibly going to become a master tenant, or who are looking to engage in a subtenancy. And that information, the way to reach them, I mentioned before, and is also on our website. And of course, I'm happy to discuss this further with the Commission. And that concludes my report.
Thank you, Mr. Manager. Commissioners, are there any questions to, yes, Commissioner Maggio, please.
Yes, question to Jonathan. So it's required by the tenant always to report to the owner or manager that a new individual will be coming into the apartment. Is that correct?
That depends on the terms of the lease. That's governed by the terms of their lease. But I would encourage people to, before they bring in a roommate or any kind of extra person into their unit, to either reach out to the division, because there are certain additional tenants that can be brought on as a matter of right, but also to consult their leases. And of course, if they're not sure about what their lease provides, there are resources beyond the division in the community that we can point folks to get legal advice.
So I don't have to announce, if I'm a tenant, that I'm bringing now in a roommate to anyone other than myself? Is that what you're saying?
No, I'm definitely not saying that. I'm saying you need to, a tenant needs to consult their lease, or if they have questions about which people they can bring in as a matter of right, they should consult with the division, and we can talk about the provisions in the ordinance. But that said, it's probably a good idea to keep open lines of communication with your landlord, because nobody likes surprises.
Well, I would think you would want or be required to announce to the owner or the manager that there's someone else there.
Often the case, I'm sure. But it's specific, we have to, specific cases, I don't want to make a broad sweeping generalization, because there are certain situations where that might not be the case. But like I said, generally a good idea to keep open lines of communication. And I'm sure in most cases it would be something you'd want to inform your landlord of before doing so.
Thank you.
Commissioner Bergstein, please.
Jonathan, as much as I try and stay abreast of all the bills before the assembly, the numbers kind of befuddle me. The one that you mentioned, I know there's one bill under consideration that would, there would be a program where a landlord would get paid 80% of the past due rent and then would waive the 20% balance. Is that the bill that you were discussing, or is that a different one?
I believe that, well, it's understandable it's confusing, because they start out with one number and then they get, put in another number so that they can get it through. That is, I believe, also SB 91 currently. That was AB 16, I think, but I believe that has now been grouped in with SB 91. So yes, that looks like it's coming down the pike as well.
I think it's critically important. I know that the overarching concern has been to make sure that no one becomes homeless because they can't pay their rent. But in essence, it has created a second layer of unemployment, particularly for most of the landlords in West Hollywood were mom and pop. You know, we're not large corporations. We own one building, or the family does. So this might be an excellent resource to bring some equity back into the game. One of my concerns is the landlord is not required, as I read it, to accept the assistance and could possibly use that as a tool to dislodge a long-term tenant at some points. I'm grateful that we have legal assistance available for our residents in case that should arise. Thank you.
Thank you. Vice Chair, I think, right? You have a question?
I had one question on the rental relief / eviction, and then a few things on the subletting. On the rental relief, I think you mentioned signing up, the possibility of signing up for future relief from the county and maybe the feds. I know the city itself has offered assistance for a long time. Is that still available as well?
That is, and that was already on our renters assistance page, and that information is all still there, and folks should definitely visit it if they're having problems paying the rent. But the county program was something we just added.
Great. And I believe that a person could have assistance up to 4 times now with a cap of $1,000. Do you know if that's the case?
I don't know what the current limits are, because that could change, but the Social Services Division manages that program, and has the contracts that program relates to. But that information is on the website. But people should feel free to reach out to us, because we'll put them in touch with the people they need to speak with.
Okay, thanks. And then on the subletting piece, there were a number of things where this came up because we had a case that involved a master tenant and a subtenant. And I get the sense that not many people in our city are aware that the laws for the rent stabilization ordinance apply to master tenants as well. And I was wondering a few things. So I believe a master tenant doesn't have to register as any other landlord would. Is that right? They don't have to write, this person moved in at this rate, here are the housing services.
Right, that's correct. And the reason for that is that there's been no vacancy. It's a continuation of the existing tenancy, and of course, the re-registration is only required upon a full vacancy of the unit.
And do they have to notice any rental increase in writing as other landlord would? Do they have to notice about the AGA and what it is in writing?
That's not a requirement currently. What we anticipate is that no one would be price gouging essentially and charging their subtenant anything beyond the MAR. To do so would be illegal.
Yeah. And so for the MAR, is it your interpretation that a master tenant can't charge more than what they pay for the unit, that the MAR for the unit also applies to them as a master tenant?
That's correct.
All right, thank you. One thing I was thinking for the entire commission is it might be worth considering, because I got the sense that this might be a little bit of an afterthought of just applying everything to master tenants as well as what we traditionally think of as landlords. And there might be some things that, that might make sense to do a little bit differently or to notice in different ways, such as housing services. If it is a landlord that has to paint, that has to maintain everything the same, it might be a little different than if it's more of a roommate situation and, a blender breaks and the person who's the master tenant can't afford to replace it and it wasn't necessarily something that was envisioned or thought out. So we haven't had people come with things of that nature that are just kind of household shared things. But one reason we thought about discussing it was because of that. And also, I believe in San Francisco, they passed a law to restrict what a master tenant could charge to the subtenants. And there's a question of if there should be some kind of limit of the proportionate share or something like that. So I don't know if other folks are interested in agendizing, possibly taking action on one or more of those issues to kind of flesh out, should anything be different when it comes to subtenants and master tenants versus just applying most everything that applies in the rent stabilization ordinance.
We're going to be taking a pretty close look at the regulations, and I think that as we bring things back to the commission, that would certainly be something that I would be looking at.
Great.
So I could see it going forward in the near future.
yeah, would be interested. I'd be interested to hear your recommendations. That's it for me.
Thank you. And just to clarify, in West Hollywood, if the property owner allows the roommate to move in, so the property owner cannot charge the master tenant an extra rent. And I guess that's correct.
That's correct. The more is the more.
The more is the more.
Based on the base rent.
Yeah, yeah, I would have probably some other questions, but when we have this agendized, I will probably come up with some other questions regarding this master tenant / roommate scenarios. Other questions, commissioners? If not, thank you, Manager Holub, and we can move on to the commissioners' comments. Commissioners, are there any comments at this time? I don't see any. Or see Commissioner Maggio? Yes. Commissioner Maggio?
Yes, I just wanted to report to the commission. I did receive my first Moderna, and I'm scheduled to have a second if I could make the appointment in 4 to 6 weeks. But I've been concerned about so many seniors in the city of West Hollywood who have been calling me. Some are not so acute to have the ability to work on the computer to make the appointment and even find their way there. And actually, I don't know if Council Member Erickson is still watching. I wanted to bring that to his attention before he left, that we need to help so many of the seniors here in West Hollywood to get to that first step. So I'm asking all the commissioners here and staff to listen to what I'm saying and find a way for these individuals to be helped at this time. I would appreciate that.
Thank you, Commissioner. Thank you. Such a great comment. Other commissioners? Commissioner Kirkus.
Yeah, I just wanted to add to the AB 80 and SB 91, those eviction protections. Someone asked about whether what happens if the landlord doesn't accept the money, and there are provisions in the law that would pay 25% of the rent in arrears. That's for the tenant, so that the tenant could not be evicted, because under the law the tenant is required to pay 25%. So if the landlord didn't voluntarily accept the money and the agreeing not to evict the tenant or to absorb that other 20%, then the tenant would get money directly to pay for the 25%. So they would not be able to be evicted. They would have a larger bill at the end of their tenancy, at the end of this law, that they would owe, but they would not be evicted for it.
Thank you, Commissioner. Well, I just wanted to kindly remind you, commissioners, during the appeal, the commissioner should not should not turn off the cameras. We should be always visible and present. So if you will need a few minute recess, let me know before the appeal, before the hearing, before the appeal. But during the appeal, I would ask the commissioners to always leave the cameras on and be visible, all right, at all time. And I also want to point out that if you reviewed the no, that's later on. All right, I don't have any other comments. I don't see any other commissioners with the comments, and so with that, I would probably move to the appeals portion of the agenda tonight. And before we begin, I want to confirm with Mr. Secretary if the parties are present.
They are.
And are available.
Yes, I can admit them now.
Okay, please.
Hi, this is Doug.
Okay.
Did Zach connect up or not?
Mr. Secretary, we have the tenant and the landlord both?
Yes, I'm here.
All right. Okay, so then we will have our appeal now. And before we begin, I would like to take a moment and explain the process of the appeal tonight. First, the commission will hear the staff report presented by the department's legal counsel, Mr. John Natalizio. And after that, the commissioners may direct their questions to the legal counsel. After that, each party will have 5 minutes to address the commission and present their case. The appellant, in this case, it's the tenant, will go first. And the appellant will be able to divide the time between the presentation and the rebuttal portion of the appeal. So the 5 minutes will be divided into two portions. The respondent will go next and will take 5 minutes entirely to address the commission and present their case. Well, please keep in mind that tonight's appeal is not a second hearing. The commission will review the grounds for which the appellant believes the hearing examiner's decision was an error. So therefore, no new issues may be considered by this commission, nor may new evidence be admitted unless it is demonstrated with the evidence that the evidence could not be with due diligence have been presented at the hearing. So please keep your comments to the issues presented at the hearing. The legal counsel or I may interrupt you at any moment if you go off topic or introduce any new evidence or information. Once I close the public comment portion of the appeal, the commission will begin the deliberation. So with that said, again, we have the tenant and the landlord, both parties present, and Mr. Natalizio, this is your time for the report.
Good evening, Chair, Vice Chair, Commissioners, the public. My name is John Natalizio, and I am the legal counsel to the Rent Stabilization Commission for the City of West Hollywood. This appeal was filed by Zachary Snyder, who was a tenant at 8558 Holloway Drive in Unit 308B. Mr. Snyder originally applied for a determination of the maximum allowable rent and whether the landlord had retained rent in the excess of the MAR. The hearing examiner determined that the landlord had illegally increased the rent an additional $300 a month beginning in August of 2019. The hearing examiner found that the unlawful rent increase resulted from the addition of a third roommate to the unit. The hearing examiner noted that the lease included a provision that the addition of a new roommate would result in a $300 rent increase, which the hearing examiner found violated the rent stabilization ordinance. The hearing examiner calculated the MAR and found it to be $2,538.05. The hearing examiner calculated the excess rent between August 2019 and October 2020 and found that the landlord had retained excess rent in the amount of $3,165.46. Mr. Snyder's appeal is limited in scope, and he is only appealing the hearing examiner's calculation of the excess rent. He is not appealing the MAR determination. Specifically, Mr. Snyder is challenging 1 month's calculation, which is labeled as March 2020 in the hearing examiner's decision. Mr. Snyder states that the March 2020 rent payment reflects a one-time rent reduction, which the landlord agreed to as payment for damage that occurred to his roommate's vehicle due to rusty water leaking from the apartment building. Mr. Snyder argues that the hearing examiner incorrectly determined he owed the landlord $815.54 for the March 2020 rent, but instead should have determined that there was an overcharge of $306.75. Mr. Snyder believes that the total amount of excess rent should be $4,287.75. Mr. Snyder believes that it should not be the $3,165.46 determined by the hearing examiner. Mr. Snyder also seeks reimbursement from the landlord for the $25 appeal filing fee. Staff has reviewed the hearing examiner's decision in the appeal application and recommends granting Mr. Snyder's appeal and modifying the total amount of excess rent retained by the landlord from $3,165.46 to $4,287.75. Staff finds that the March 2020 rent should reflect that Mr. Snyder was overcharged $306.75, and he did not owe the $815.54 to the landlord. Staff also recommends denying the request for the $25 appeal filing fee, as no such recovery provision is permitted in the regulations. As legal counsel, I have reviewed the appeal and think that there is evidence to support the issue raised in the appeal. But you as the commission have the power to affirm, reverse, modify, or remand the appealed determination of the hearing examiner as you deem fit. Your review of the hearing examiner's decision is to determine whether substantial evidence supports the hearing examiner's conclusions. In this instance, you were to determine whether there is substantial evidence that supports the hearing examiner's determination that the landlord collected excess rent in the amount of $3,165.46, or that Mr. Snyder's appeal is accurate and the excess rent should be in the amount of $4,287.75, or a different amount that the commission deems fit. Thank you.
Thank you, Mr. Natalizio. Questions to the legal counsel? I see Commissioner Maggio raising their hand.
Yes, to legal counsel. So therefore, if there was a leak and damage to this car, then that means the landlord is, in a sense, responsible. Is that correct?
In terms of responsible for the damage to the vehicle?
Right, and then the higher amount of to be given in the rent. No?
So to answer the question in terms of why that rent adjustment happened, the hearing examiner found that the damage to the vehicle was due to the property owners, the apartment building, and that the landlord agreed with the tenant to that one-time rent reduction, and that was what was then paid by the tenant.
So that was the compensation, I guess you would say.
Correct.
Thank you.
Thank you. Other commissioners? All right. If no more questions to the legal counsel, so I'm going to open the public testimony portion of the appeal. And the first, I would like to invite the tenant, Mr. Zachary Snyder. Mr. Snyder, as I said, you will have 5 minutes to present your case, and you may take the 5 minutes at whole, or you may just divide into two segments, a presentation portion and the rebuttal portion after the landlord speaks. So how you may, how you wish to proceed?
Dividing it into the two portions is fine.
Okay, how many minutes you want to take for presentation?
Just 2 is enough.
Okay. Mr. Secretary has noted 2 minutes for the presentation and 3 minutes for the rebuttal. And sir, as a reminder, please do not present any new evidence. Just stick to the original issues discussed at the hearing. You may begin, and for the record, please state your name and the city of residence.
Name is Zachary Snyder. City of residence is West Hollywood.
Thank you. You may begin.
Okay. Well, I agree with everything that was presented already. So all I'm going to add is that based on the original hearing examiner's decision, the landlord, Mr. Connor, has already reimbursed us the $3,165.46. So all I am asking for is a remainder due of $1,122.29 to make up that total amount. I listened and you said that the recommendation was to not reimburse me the $25 appeal fee. I would argue against that. And I would also point out to the commission that due to an error made by the hearing examiner, an accounting error, money that was owed to myself and my roommates has now been delayed 2 months more than it should be. In addition, all the time I've had to spend prepping for this hearing is time away from my work. So it's my time is valuable. So I would also present to the commission that there should be some sort of compensation from the city for my time and for the delayment of payment if you find in my favor. And I will actually cut my time short there because you have all the evidence presented to you that I think is warranted.
All right. So whatever, if you're done with your presentation, so whatever time you have remaining, you may take it after the owner speaks. Commissioners, are there any questions to Mrs. Snyder at this time? I've seen none. And with that, I would like to invite the property owner, Mr. Carner.
Yes, hi, this is Doug Carter,
Mr.
General
Carner,
Manager acting on behalf of the owner in Los
Mr. Carner,
Angeles.
just 1 second. You will have 5 minutes and you will just address the commission, 5 minutes, and then again, please stick to the issues discussed at the original hearing and don't bring up any new evidence to the commission, please. Thank you. You may begin now.
Yeah, okay, that's fine. I'm not even sure why we're involved. Zach's issue is he feels that your hearing officer did the math wrong. And so if you did the math wrong, let us know if we owe anything and we'll happily pay it. If the math is right, let us know that. Either way, I hope we're not getting charged for this because Zach doesn't have a problem with what we paid. He's having an issue with what your hearing officer totaled. And our feeling is, okay, whatever the hearing officer feels, if they made a mathematical error, have them correct it, which is what this call's about, and we'll adjust accordingly. That's the entirety of my testimony here.
All right, that concludes your statement.
Yes,
right.
We're not introducing anything or charging a thing. It's literally just what the hearing officer came to.
All right, thank you. I appreciate that, Mr. Carner. Commissioners, are there any questions to the owner? Okay, I see none. Mr. Snyder, you can come back. And Mr. Secretary, how many minutes Mr. Snyder has?
3 minutes and 40 seconds.
Okay, you have 3 minutes and 40 seconds to address the commission, Mr. Snyder.
Well, again, that's not needed. All I would just add to my original thing that I was saying that I do believe there is some sort of additional compensation owed to me for my time and this delay. And I would set forth just the amount of $150 to the commission at their discretion. They can choose to.
Well, that's irrelevant. So this is not something that we're going to discuss now. It was not part of the bill.
Okay.
All right. So
then I conclude my argument to the case.
Okay. Thank you.
Thank you.
Commissioners, no questions to the owner or the tenant. Commissioner Chris, please.
I have a question for legal counsel. We don't have, the commission doesn't have the authority to grant anything, any costs involved or anything like that, right? To either party, regardless of what the situation is.
That is correct.
And then was it your recommendation? I didn't hear this, but I thought I heard the tenant say that it was your recommendation that we not, actually, do we even play a role in the $25 fee for filing? And if we do, was it your recommendation that we not reimburse that or waive that?
Correct. So there's no provision in the regulations that allows for recovery of the appeal fee. There is one for the application fee at their hearing examiner level, but there's nothing in the regulations relating to the appeal fee. So my recommendation was to reject that request in the appeal.
Do we have the authority to grant the request?
My position would be it's not permitted in the regulations to allow a recovery of the appeal fee. And so my position would be that you don't have the authority to grant that $25.
Thank you.
Commissioner Maggio?
It seems if there is any extra compensation that they would have to go through the court system, small claims for certainly any fee recovery of that nature.
Is that a question, Commissioner Maggio?
That was a comment.
Okay. All right. Any questions to the legal counsel? All right. I see none. With that, we will move on to the. All right. Let me formally close the public testimony portion of the appeal, and then we'll move forward to the commissioners' deliberation. Commissioners who would like to begin? Commissioner Charity, please.
Yes, I think oftentimes we have many gray cases, and this one happens to be black and white and mathematical, that there was a deficit that was subtracted that was incorrect, the $815 and change, and that also there was an overcharge of the $305.75. And I do appreciate the tenant's argument with trying to recover those fees. However, we are bound by the code of West Hollywood that we don't have it in our power to grant the reimbursement of those fees. But oftentimes the law does cut both ways. And because of the great RSO that we have in West Hollywood, that we're able to award this tenant the excess rent of $4,287.75. So while it doesn't allow us to award those fees, it does allow us to award these excess rent charges. And that'll be the end of my comment.
Thank you, Commissioner. Other commissioners? Anyone? Or Commissioner Copeland?
Aye. I agree with Commissioner Charity. I think seems to be pretty black and white. There was clearly an error in computation on behalf of the hearing examiner on the overpayment of rent. And I agree with staff's recommendation for an adjustment on the overpayment of rent. That's all.
Okay, thank you. I'll go by one. Commissioner Bergstein, please.
I'll just echo Commissioner Charity's comments. This is a pretty straightforward matter for me, which is a mathematical error in computation. So I'd be voting in favor of staff's recommendation. As far as the request for time spent, I totally get that. I took some of the small claims court once and asked the judge to award me lost pay for being in court, and I was denied at the court level. But I do understand the request. Unfortunately, there is nothing in our ordinance that allows us to award either party the time they spent on the matter. But I will be voting in favor of staff's recommendation.
Thank you, Commissioner Bergstein. Commissioner Maggio?
Well, let me remind us of Rent Stabilization Ordinance 17.08.110.2H2.17 for tenancies that begin after December 31st, 1998. As here, the rent initially charged comprises the base rent under the Rent Stabilization Ordinance. And to support the argument is also Section 1708.10 and 17.40020 for tenancies created after January 1st, 1999. So therefore, I support the hearing examiner's conclusion. I think I already made my remarks in regard to any compensation for overcharges. There are other ways, we can't do that, but there are other ways that maybe they can gain some sort of compensation through perhaps small claims court, or if it's a larger amount, I suppose onward, but it isn't. So that's my comment. Thank you.
Thank you, Commissioner Maggio. Vice Chair O'Keefe, please.
I think this was pretty cut and dried, as some fellow commissioners have said, that I agree with the staff analysis. It was an error on the part of the hearing examiner. Regrettable, we do not have the authority to waive the appeal filing fee or to provide compensation for time, but we do have authority and should to reverse the decision and provide the adjustment in the fee and adopt the resolution proposed by staff.
Thank you, Vice Chair. Yeah, this is really black and white, and I just want to echo to what the commissioners have said before me. I agree with the staff's recommendation to affirm in part and reverse in part the examiner's decision. And the good thing is there's no really dispute or question about the MAR. The MAR has been determined correctly. The whole thing is about the examiner incorrectly calculating the overpayment for March 2020, and that has been corrected by the in the staff's recommendation. I agree with the recommendation to deny the reimbursement of the $25 filing fee because we don't have, it's outside of us. We're bound on, and we also have no authority to award any additional compensation, whether it's fortunately or unfortunately, but we cannot do that. We don't have a legal authority to do that. That could be or may be a civil matter outside the rent stabilization jurisdiction. So you may seek legal advice for that matter. And other than that, I would like to see if you commissioners have a motion. Commissioner, was that Commissioner Purpose?
Yeah, I just agree with my colleagues on everything that's been said. So I will move to adopt resolution RSC 21590, a resolution of the Rent Stabilization Commission of the City of West Hollywood, affirming in part and reversing in part the hearing examiner's decision in D4552.
Thank you, Commissioner. We have a motion.
I'll second that motion, Chair.
Okay, we have a motion, Commissioner Purpose, and we have a second, Commissioner Charity. Now, any further discussion on this motion? If not, Mr. Secretary, we may take a roll call, please.
Commissioner Bergstein,
Aye.
Commissioner Charity, Commissioner Copeland,
Aye.
Commissioner Kirby's,
Aye.
Commissioner Maggio,
Aye.
Vice Chair O'Keefe,
Aye.
Chair Topshin.
Aye. The motion passes, and to the parties, you will be placed back in the waiting room. If you would like to watch the rest of the meeting, you may do so. And if you will have any questions about the appeal tonight, you may contact the rent division staff during the normal working hours. Mr. Secretary, can you remind the contact phone number, please?
Yeah, 323-848-6450. Email is rsh@weho.org.
Thank you, Mr. Secretary. All right, that concludes the appeal portion of tonight's agenda. Commissioners, do you need a break?
Yes.
Or we can, all right, Commissioner Maggio, so requested a break. We'll meet in 3 minutes. We'll be back.
Chair, if you're speaking, you need to unmute.
Thank you, Commissioner Bergstein. I forgot. Yeah, I'm waiting for who's missing, Commissioner, or no, who's missing? No. Commissioner Maggio, right.
It's
All right.
it's pouring outside. I want everyone to know.
Okay. Just for the record, the commission had a 3-minute recess, and I call this meeting back to order. We are moving on to the next item on the agenda, item number 10, unfinished business. The commissioners, you probably remember that a couple of meetings ago, we requested that staff does some research and draft a letter regarding broken elevators, a letter outlining the commission's concerns regarding broken elevators for commission to review and forward to either the Human Services Commission and Disability Advisory Board and or the City Council. So the staff prepared that letter that was included in the packet, and we're going to discuss it now. And I will like to ask the manager, Mr. Hall, please, if you have your report.
Thank you, Chair. Again, good evening, Vice Chair as well, and Commissioners. Jonathan Hollow, Acting Manager, Rent Stabilization and Housing Division. As the Chair mentioned, there was a robust discussion on elevators on December 10th, 2020. That you were joined by the Code Compliance Division Manager, Danny Rivas, and a discussion on the issue of broken elevators, their effect on residents, and steps to ensure compliance and reduce the impacts on tenants. Following the discussion, staff indicated they would prepare a letter based on that discussion for the Commission's review and to send to any combination of the City Council, Human Services Commission, or the Disability Advisory Board. Having reviewed the proceedings, staff prepared the draft letter attached to the staff report and recommends that the Commission accept it for presentation in final form for the Chair's signature on the Commission's behalf for transmission to the City Council with copies to the Human Services Commission and the Disability Advisory Board. And I'd also like to thank Commissioner Copeland for pointing out to me a little error I made at the bottom of page 1, where the last paragraph says tenants may also to go. I forgot the word choose. It should say tenants may also choose to go through the rent decrease hearing process. I apologize for that error. And of course, whatever we send out will include correction and whatever else the Commission decides to put in. Thank you.
Thank you, Mr. Manager. Commissioners, Commissioner Curtis, please, if you have questions.
Yeah, I have a couple, maybe some suggestions that either can be accepted or not. But going through the letter, there were just some minor changes that, like in the first paragraph, it says the Rent Stabilization Commission submits this letter to be highlighted the negative impact of inoperative elevators on our community members. I was just going to say residents there. I thought that was more consistent with what we were talking about throughout. And then on the third paragraph, in the final sentence, and while city staff always work in the spirit of cooperation with property owners who seek to perform timely maintenance, I thought that sentence didn't necessarily sound like it would come from the Commission. I thought that maybe if we could change it to, well, we trust that the city employees do this, or I don't want to say that they don't. I just want to say that we trust. We don't really know what they do out there. And then on the fourth paragraph, oh no, that was your change. Never mind. Next page. On the first paragraph, on page 2, where it says, if a tenant, it's the third line down, if a tenant is granted a rent decrease as a result of this process, they would be eligible to begin deducting, and then it goes on. I didn't feel like the sentence encompassed it's actually the most likely the elevator is going to be in a common area. So it wouldn't just be the tenant that receives that amount. It would be the entire, all the units. And I just didn't feel like that sentence incorporated that at all. And then in that second paragraph / sentence there, that starts in the Commission's opinion. I thought we could, going back to our conversation or our discussions at the last meeting, that our actions aren't intended to be punitive. I thought we could accomplish the same thing by just simply saying, in the commission's opinion, these options provide tenants with prompt and effective relief. That we could just ignore that we're trying to incentivize through fees but those are my thoughts on the letter.
Sorry, Commissioner Kerpes, could you repeat the language that you just gave? I didn't catch that.
On the last one, it's actually this, I'm just deleting a portion of it, but it said, in the commission's opinion, these options provide tenants with prompt and effective relief. So I'm just deleting everything after options, so rely, and I'm deleting up until or, landlords or provide tenants with.
If I may, Commissioner Kirby's, that transforms the meaning to the opposite of what it was. The point was that the options that currently exist don't incentivize prompt and effective relief usually.
No, we're saying the changes we're making, I believe, is what the sentence is supposed to be saying. The sentence says, in the commission's opinion, these options rely on remedies that do not always incentivize elevator repairs in a timely fashion. Oh, I see what you're saying.
The whole reason we
okay, so in the commission's opinion, these options do not provide tenants with prompt. That's what I meant to say.
That's needed.
That would change the absolute meaning. That makes sense.
Can I offer up on that?
To add, do not. Sorry, Commissioner Bergstein.
The prior paragraph, Commissioner Kirby said, if a tenant is granted a rent decrease and so on, would you be more comfortable if tenants are granted a rent decrease? Because it's generally all of the tenants in a building unless they opt out. And we have seen some cases where not every tenant joins in and wishes to benefit from a rent decrease. So if tenants are granted a rent decrease, instead of if a tenant is granted a rent decrease, would that be clear language for you?
Yeah, I believe so. I just didn't think the way it's written now, it incorporates the fact that it leads you to believe that the one tenant would get $11 to $69, and when in reality, it's going to be more than that, especially in a building with elevator, because it's more likely to have more tenants.
I see.
But yeah, that would be fine. I mean, just pluralizing it.
Okay. Anything else from you, Commissioner Kerpes?
That's all I have.
No. Okay. Vice Chair.
Yeah, I have 3 suggestions, which I definitely would want to see because they're substantive, how my fellow commissioners feel about them. At the end of the letter, it's kind of bigger picture. For the suggestions, I had 2 or 3 additional suggestions that aren't within our commission's purview, but it would be additionally, we recommend that the council consider. First, I would say substantially increasing the fines, at least in the event of a willful failure. And that's because right now the fines are less than it costs to fix that elevator. So if you've got 3 times when they're not fixing an elevator, I'm concerned that there's no financial incentive to actually spend the money. I don't know how we want to do this. I can just list all 3 of them and then people can let me know if they agree or disagree, I guess. Second, it includes that we would suggest revise the West Hollywood Municipal Code section 17.52.110 to have the relocation. There are probably a lot of cases where the person won't want to or be able to be relocated because they can't get down the stairs to be relocated in the first place, but they can't go out to get groceries. So assuming we have the legal authority to, I'd suggest it be that we require landlords to offer either to relocate them or that they cover costs of delivery fees, because that actually might be more important for people to, endure not having a working elevator if they are reliant on a working elevator. And then finally, in the case that we had, I believe we heard that even after they repaired the elevator, it was still terrible and it was really old, and it sounded like it was a house apartment that was governed by historic preservation. And my strong feeling is that if there is a conflict of historic preservation and accessibility, then historic preservation should yield. You should be able to modernize the elevator for the functionality of residents if that's what's necessary. So I would suggest the third thing be exploring if our city's housing preservation ordinance should be modified if it is standing in the way of modernizing elevators and completing timely repairs. And also saying that considering the values, consider whether when the values of housing preservation and accessibility are in conflict, accessibility should be prioritized. So those are the three remedies that I would suggest we add that the city council consider.
Thank you. Commissioner Bergstein, and next is Commissioner Maggio.
Vice Chair, I'd just like to offer an amendment to your amendment. When you talk about the landlord being responsible to reimburse for the costs of food delivery, I would be hesitant to limit it to just food delivery. There may be other services that a person would not normally incur a cost. It might be specialized transportation to a medical appointment. It might be a dog walker who can go up and down the stairs. So if you could broaden that to, and you can say it better than I can, but something, any additional costs that a tenant may incur specifically because of the lack of the elevator.
I think that's excellent. Very friendly amendment is accepted. Thank you.
All right, Commissioner Maggio.
I'm most concerned about the handicap. You know, I live in a building where the elevator has been out for 2, 3, 4, I think once up to 5 weeks. I'm glad there's a stairwell because I get my exercise. But I'm most concerned about certainly the handicap. And I know people have gotten stuck and they can't get down. And so they do need help. So we have to find a way to help the handicapped. And no matter what it takes, whether we have to bring them food, whether they have to be helped down the steps to go to an emergency appointment, maybe to the doctor. But the concern definitely has to be for the handicapped. Let me just also make a comment about elevators that break down. They can't always be fixed immediately. In this particular building, if a part is needed, you have to send to Germany for it. So, but I think the emphasis definitely has to be on those who are stranded or stuck. We need some way to really help them and to really spell it out clearly. What are we going to do? I mean, what can we do? And then Rob just brought up an idea about if they have pets, or who's going to bring them out, and how are these people going to be compensated? So that's my main concern. Thank you.
Thank you, Commissioner. Commissioner Charity, next, Commissioner Bergstein.
At the end of paragraph 3, first page, I just wanted to make one small addition for an additional idea. So the last sentence reads, and while city staff always works in the spirit of cooperation with property owners who seek to perform timely maintenance in good faith, what I wanted to add after that was unreasonable or intentional delay and chronically inoperable elevators. That just basically is encompassing an idea that I plan to talk to any council member who was interested about, because the idea is that elevators are expensive to replace, and some of the elevators that I talk to tenants with are trash and they are broken over and over again. And instead of investing the money in replacing that elevator and getting a new one, it just continues to break down and the tenants cannot rely on it. So that's why I wanted to add the just preposition and chronically inoperable elevators.
Thank you. Commissioner Bergstein.
All right, Vice Chair, another question for you. You talked about if there was a conflict between the elevator repair and historic preservation. I don't know if that commission could clarify. I'm not sure that the mechanics of an elevator would be covered historically. Wouldn't it mostly just be the cab itself? You know, if it's, you know, inlaid walnut from 1942, but the parts itself, maybe we would want historic preservation to clarify whether the working mechanisms themselves would be historic or just the.
I'll respond. I would suggest just asking it as a question because I don't know enough about historic preservation. So I would frame it just as, should they be amended? I personally, if there's an old elevator, you know, if you have a modern elevator, it probably wouldn't fit with the same inlay if it's completely modern. So if it's completely replacing it, I would be surprised if you could have, you know, I've seen some very beautiful old elevators that I just don't see fitting into modern ones. So there could be a point at which it's either get rid of this old junky elevator, even though it's got some historic value, and get a new one that works, or just keep repairing, as Commissioner Charity was alluding to. And I would say get rid of and get a good one, and that might be impossible to maintain the aesthetics.
Thank you, commissioners. Commissioner Majid.
You know, we can't do anything about this at this moment, but I think this could be a good opportunity to actually bring in some elevator experts to come to us and talk about all these variables and educate us. I mean, what can be done? What can't be done? Can we really make an old elevator? In other words, keep the guts of the old elevator and throw out the rest? Can we really do stuff like that? So unless we learn about all that, you know, we certainly, you know, are not experts on this. And maybe we've had people come before us, certainly on smoking ordinances and those ideas. We could have someone come to us and talk about elevators, what can be done, what can't, and how we can create safety always with them. Thank you.
Thank you, Commissioner. Vice Chair?
I think, unfortunately, it's beyond our authority to do much more than write a letter flagging these issues. But if the council decides to explore all these possible suggestions, they probably will want to get a reality check for it. Commissioner Charity's suggestion of the revision, I liked it a lot. And it made me think, I wonder if on the same first page in the next paragraph, it talks about the penalties. And I think they're all for repairing. If code compliance can't actually say you have to replace it instead, then I'd suggest that they also be able to order that, because as Commissioner Charity was saying, there are some cases where it'll just keep on not working if you don't replace it. So I guess I would revise my earlier suggestion of the 3 suggestions to also include adding that if they can't already, that the code compliance should have the authority to order the complete replacement of an elevator if it has chronic functionality that warrant replacement.
Good, thank you, Vice Chair. Other commissioners, any more comments? I think this was Commissioner Copeland. Yes, you haven't spoken.
Yes, I actually wasn't there for the meeting when this discussion happened, but I did watch the video, and I was very happy to see that this situation was addressed, because it is critical. I agree with the changes that the fellow commissioners suggested. I especially like the option of either relocation or reimbursement of expenses and related services, because that would vary, you know, according to the tenant, you know, according to the resident. They would have different needs. Some might absolutely need to be relocated, and others say, well, I can, you know, if it's going to be a certain amount of time, as long as I have someone to walk the dog or someone to deliver groceries, or then I would be okay. So I like the either or option in there. I think it's great. And all the other changes that, especially with chronic, I mean, this is a serious life issue if you can't have access to your apartment. So if this is something that's happening every month or, you know, over and over again, then it becomes obvious that this is not going to be something that they're interested in addressing in a serious manner, that code compliance would have an option, possible option to require that it be replaced at some certain, but if it's something they could look at, I think that's a great idea. Yeah. Great suggestions. I agree with them, and thank you again for addressing this. That's all I have right now.
Thank you, Commissioner Copeland, for the comments, and thank you, commissioners. I think this is a great discussion, and I would agree with most of the things that you brought up, and I think everything that you suggested. And I saw Mr. Holland was taking his notes. I'm pretty sure everything will be reflected in the letter. I just have maybe one or two little things here and there. On the first page, second paragraph that mentions disability, and I know Commissioner Maggio mentioned the handicap also. So I think I don't know how can we expand, or do we need to expand? If we mention handicap, I would also like to include seniors, because we may have seniors who are not handicapped or disabled, but they may have some medical issues that would, make their life a lot harder, more difficult without the elevators. So if we want to maybe include different various categories, if we need to expand at one point, because that obviously would affect other other categories. So on the other note, I also wanted to mention that that was kind of my recommendation, and I clearly remember that. I already mentioned that before. If we could include the requirement of a posting inside the elevators to provide a code enforcement contact phone number and other agencies that, or health department, or I guess California OSHA number or something, agency that would be mostly West Hollywood code enforcement, that the tenant can call even from the elevator and report, and maybe we can have a dedicated line. So when the 10th person calls and says, if you're reporting a broken elevator, dial 2, and then the person will just get exactly to that person or the number who will be able to help with the broken elevator. So to report these issues promptly with no delay, and have a record of such report, that will be important, especially if later on there would be a decision on the rent reduction. So when the tenant called, specifically the time and the date when the issue was reported to the city. I want to have it as a requirement. The other thing is, I don't think it's kind of for the record. It's for the viewers mostly, because the staff report references the West Hollywood Muni Code, section 17.52.110, that talks about temporary reposition for authorized corrections. That's the section that requires the landlord to temporarily relocate affected tenants to a hotel or comparable housing units when the landlord is required to conduct repairs that would raise it to a certain level of the habitability issue that the tenant needs to be relocated temporarily. Since we mentioned, the commissioners mentioned the relocation, the staff mentioned the relocation, I want the viewers to understand that we're not talking about permanent relocation. This is a temporary relocation benefit for certain tenants who may be required to relocate temporarily for the landlord to complete repairs of the elevator. So that's what I just wanted to have it on the record for the viewers mostly. Other than that, Mr. Holub, so what do we need to do? What type of action we need to take at this point? So every commissioner was able to share the thoughts and make the recommendations to amend and to change this letter. So what's next? We don't need to vote on this, right? Or we have to vote?
Receive and file.
Okay, Mr. Manager, that would be receive and file?
No, one of two things. I can either integrate all these changes and just bring back a final version to the next meeting, where hopefully that I got everything. Of course, I'll go back and review. I think I did get everything, but if I can go back and review, it would be helpful. And then hopefully that'll be the letter that the commission votes on, the chair executing to be signed. Of course, you could make a motion tonight, but if you can give me the benefit of 2 weeks, then, that would probably be the simpler approach.
I think that would be the best approach. If the commissioners, if you would agree, I would agree that the Mr. Manager will just draft the amended letter with our recommendations and bring it back to the next meeting in a couple of weeks. We'll have a chance to review and then receive and file after that. So Commissioner Maggio and then Vice Chair next.
So to Jonathan, you're going to now incorporate all these thoughts and ideas that we have discussed tonight. Is that correct, in order to finalize this letter?
That's correct.
Thank you.
Vice Chair?
I just have a very slight suggested tweak to your recommendation. I like the idea of having the flyer on the wall. My one concern is that if it only has the number of like code compliance and state governmental agencies, that people might not call the landlord first, and it might delay them actually fixing it if the landlord's got like somebody that can fix the elevator right away. So I'd suggest adding to it like it should first have a contact for the elevator, whoever the landlord designates to be the elevator repair person, then code compliance also if there's chronic problems or if they also want to contact the city.
Yeah, I think it's a great idea. So I have no problem with that. So yeah, I think it's a wonderful thing to provide as much as information or contact information we can. With that, then, Mr. Manager, since we already know what we're doing, there is nothing else on this item, correct?
Correct.
Okay, so we'll wait for staff or Mr. Manager to bring this back at the next meeting for our review. And after that, if there are no more adjustments will be needed, we will receive and file. Thank you, Mr. Manager. Thank you, Commissioners. It was a great discussion. All right, we don't have any other items under unfinished business. The next is public comments. Mr. Secretary, do we have any speakers at this late hour?
None at this time.
Okay. All right. Next is commissioners' comments. Commissioners, Commissioner Bergstein, anything at this time? No. Commissioner Charity, Commissioner Copeland, Commissioner Kerpis, Commissioner Maggio, Vice Chair O'Keefe. All right. I also don't have any comments at this time. Well, next is staff comments. Manager Holub, anything else?
No further comments. Thank you.
No further comments. Great. All right. So then I will adjourn this meeting, the meeting of the Rent Stabilization Commission. The next meeting will be held at 7 p.m. on Thursday, February 11th, 2021 via teleconference. All right. Good night, everyone. Thank you and stay safe.